Let's move on to some different, we've got a very aggressive agenda now that we got started a little bit late. We're going to talk about some changes in the law and particularly with the NLRB's enforcement and how that affects your handbooks or could affect your handbooks. We're going to look at harassment, wage and hour, some different topics in state laws. Very briefly, we're going to talk very briefly now about EEO1 Component 2 compliance and then the Tennessee Healthy Workplace Act that has garnered some attention recently. Employee handbooks. As most of you know, before 2017, the former administration and the NLRB under that administration took a very aggressive approach. And that with respect to Section 7 of the National Labor Relations Act, which protects employees' rights to bargain collectively regarding terms and conditions of employment. They took a very expansive view of Section 7, and a lot of policies that seemed to be standard policies, civility policies, be nice policies, confidentiality policies, were suddenly being ruled by the NLRB as being unlawful under Section 7. Beginning with Boeing in 2017 and then in 2018, the new administration, new NLRB, and now the new council has issued some guidance that is sort of moving the pendulum back. And now the standard is not simply whether employees would reasonably believe that their rights are being infringed upon, but it is more of a reasonable standard and a balancing standard between the interests of the employer and the interests of the employee. You've really got three different categories of rules now. Some of them are going to be, for the most part, lawful under any set of circumstances. Things such as defaming, harassing employees and the like, insubordination towards supervisors, provisions that would, or policies that would prohibit photography in certain circumstances, and the authority to speak for the company. Those are typically going to be found lawful now. Some that are going to be sort of in that gray area are ones that deal with conflicts of interest, confidentiality and the like, and then of course ones that are almost always going to be unlawful and quite frankly have been for some time, rules that prohibit discussing wage or benefits, wages, rules against joining, quote, outside organizations, which can be code word for unions. Within the last few months, I think March of 2019, there were two different cases where agency memos or advice memos were issued that I think are helpful, and I pulled some of the policies out of that memo, and it's not working again. Okay. Dress codes, professional dress codes, once again, are for the most part lawful. Even if that dress code prohibits wearing items of apparel that may have inappropriate commercial advertising or inappropriate commercial insignias. Rules about public comments on behalf of the employer. In other words, you can't simply speak for your employer. Those policies are primarily now found to be lawful under this advice memo. Confidentiality rules, not broad confidentiality rules that simply say everything about your employment is confidential, but rules that are specific as to what is protectable and what is important to the employer, those generally are lawful as well. One thing to keep in mind, cell phone usage policies, if it's a policy that says you can't use your cell phone at all while you are at work, and not just during working hours, that is still going to be unlawful. Employees still have the right to use their cell phones when they are not on working time, when they're not in working locations, so that type of policy is not permitted. Policies requiring employees to cooperate with investigations of misconduct are, again, generally lawful. Policies that make all contents of employee handbooks confidential are not. I've seen some mostly older handbooks that employers have tried to say, this is a confidential employer document and you are not to share it with anyone. For the most part, that's ineffective anyway because you're sharing it with someone when you give it to an employee. But the NLRB, the agency, has issued that advice memo that it is still, even under the new standard, is still going to be considered unlawful. Restricting communications about wages, about compensation, benefits, and the like outside the company, again, that is an unlawful policy. Employees are entitled to discuss their own wages and benefits. Now, that does not mean that an employee can find someone's payroll that is not their pay stub and tell someone else what someone else is making because they've improperly obtained the information. But policies that prohibit discussing your own compensation are still unlawful. Okay, so a little bit about handbook policies. Let's talk some about harassment in the workplace. The MeToo movement is still alive and well. About a third of all the lawsuits that the EEOC filed in fiscal year 2018 were in fact harassment lawsuits. You probably, particularly if you're outside the state of Tennessee, because our state is not particularly active in state law, but a lot of states are looking at legislation that's either been proposed or it's in the process of being considered, and several states have new training requirements as well. New York State, New York City, Delaware, California, and then there's several others as well. If you are practicing or if you are located in one of these states, be aware that there are very specific state laws, too detailed to go into in this presentation, but in those particular jurisdictions that are an add-on to federal law with Title VII that you need to be aware of. And if you have employees who are in those states, New York City particularly is very aggressively pursuing enforcement of these types of statutes. So simply because your home office is not in that state, if you have employees that are in that state, you need to be or in the city, you need to be very aware of these new harassment training laws. Several other state laws that have come into play. State of Washington. Tennessee, I want to mention that one because Tennessee has enacted a law that prohibits non-disclosure agreements that prohibit an individual from disclosing complaints or settlements of sex harassment. Now, I want to be very clear on that because it only prohibits a non-disclosure agreement in an employment contract. It does not prohibit a non-disclosure agreement in a settlement agreement. So in other words, if an employer is either facing a charge or if they're facing a lawsuit and they choose to settle a sex harassment allegation, the lawsuit that contains that as one of the allegations, employers in the state of Tennessee are not prohibited from including a non-disclosure agreement in that settlement document. Employers cannot, however, in Tennessee have an employment contract or have in the employment handbook a provision that prohibits disclosure of harassment claims or harassment resolution. So that's the state of Tennessee. And again, you see there's several other states that are considering similar legislation about sex harassment. This is an interesting case because it came out of the Supreme Court this year. Oftentimes in employment, we think about the EEOC charge as sort of being the trigger mechanism, that whether it's under federal law or under companion state law, that an individual who feels they've been aggrieved, their first step is that they must file a charge of discrimination. Certainly under Title VII, the employee has to file a charge of discrimination within 180 days of the last event of discrimination if there is no state agency. If there is a state agency, then it is within 300 days that they have to file a charge with the companion state agency. State of Tennessee, the statute of limitations is 300 days because we have the Tennessee Human Rights Commission. Go just a little bit south of here, state of Georgia, statute of limitations is 180 days because they have no state agency. So that is generally the rule. And in the past, employers felt fairly comfortable that if an employee did not file an EEOC charge, they could not pursue you in federal court. That is still generally the rule, but this case is an interesting move away from that to some extent. An employee filed a charge alleging sexual harassment and alleging retaliation. But if those of you that work with these types of charges know, sometimes the EEOC will send a document to the employee, or the employee may look at a document that their lawyer has prepared, and then they sort of change it on their own. And in this case, the employee wrote religion on the intake document. The intake document is different from the charge. It did not get picked up on the intake document by the EEOC as part of the formal charge. The EEOC never investigated a claim of religious harassment or discrimination, and the employee received a right to sue letter only for sexual harassment and retaliation. 5 years this case languishes in federal court. And after 5 years, the employee said, hey, wait a minute, This person didn't get a right to sue letter for religion. In fact, they didn't even make a charge for religion. There's no jurisdiction. We win on the religion claim. The Fifth Circuit was not particularly enamored with that, nor was the Supreme Court. To be very clear, this is not an abolition of the requirement that a charge be filed. But what the Supreme Court said was that it is not jurisdictional in this context. Employees are still going to be required to file these, but it's not jurisdictional, but rather it is a non-jurisdictional mandatory claim processing rule. They might have kind of contrived that just a little bit to come up with that explanation that it's non-jurisdictional, but you still have to do it. The point of that is an employer can't wait for 5 years before they raise that as a claim. I think, would the case have turned out differently with different facts? Hard to say. It was a unanimous decision, so I would suggest probably not. But be aware as an employer, if you are in litigation especially, if in your records you are aware that there may be other claims that were not under that charge, be very careful not to dispose of any of those records that might be relevant to that, because as this case points out, it is a waivable deficiency in the pleading. It has to be raised as an affirmative defense and in a timely manner. Okay, enough about harassment. Let's talk a little bit about wages an hour. This is, and I recognize that neither anyone in this room nor anyone on the WebEx is selling used cars. But this is a very important Supreme Court ruling for applications that have nothing to do with cars. There is a separate exemption, as most of us know. The FLSA has numerous statutory exemptions. One of those exemptions applies to automobile dealerships in certain contexts, whether someone is an automobile salesperson and whether that applies. In the past, some of the typical language that you would see from any court case would be exemptions are to be narrowly construed because they are an exemption. And so most courts have done that. And quite frankly, as employers, we tend to do that. We try to be very careful with our exemptions and how we apply them. And if there is any question at all, the prudent employer says, well, we're going to treat that as non-exempt because we don't want to take that risk. Still prudent, but recognize now the Supreme Court has said there's nothing statutory about that narrow construction. And in fact, the court said that all that is required is a fair reading of the exemption. So, how will this shake out? Still a little early to see how it's going to apply going forward. Currently, we have a Department of Labor, that is Wage and Hour Division, that is a bit more employer-friendly. And now that you have this language from the Supreme Court that clearly states that a plain and ordinary reading of the exemption is what the standard should be, you may see some courts loosen up just a little bit on the exemption. Now, I'm not suggesting that we run out and make everyone exempt and pay them a salary and woohoo, no overtime. But simply be aware that some of the rules that we have looked at for a long time saying we have to be very, very concise on this, the Supreme Court has now said that we can look at a plain reading and not so narrowly construed. Well, again, we've got another final rule. Those of you that remember the last time we came around and talked about the final rule on exemptions for white collar, we've now got another final rule that has been proposed by the Department of Labor. This came out in March of 2019. It is a proposed rule, but the proposed rulemaking time has passed. The comment period has passed, and now we're simply waiting to see what the Department of Labor is going to do. What you see on this screen is the proposed changes to the white collar exemptions. As you know, the white collar exemptions are executive, administrative, and professional generally. And of those three, absent some specific types of jobs, registered nurses for instance, but for the most part, it's a three-part test. There's a duties test, there's a salaried basis test, which talks about deductions and being paid not by the hour, and there is a salary amount test. And what the DOL is looking at is changing those salary amounts. And you see what those amounts are there. Currently, it's still $455 a week, which is quite low. I think everyone agrees that that number is going to come up. Those of you that had to go through this analysis a couple of years ago and looked at your employees and saw that you had some folks that were going to be under the new number, some of you went ahead and made them either bumped up their salary or you made them non-exempt, and then of course the final rule was stayed, and it never went into play, and so the rule was the same back then. This time it likely will not be stayed. There will be some changes. Whether those are the numbers or not, it's hard to say, but it doesn't hurt to start thinking about it now. The difference between the last final rule and this rule is the numbers are a little more reasonable, and if you have employees who are salaried exempt but also are paid by some sort of commission or some sort of incentive pay, rather than the incentive pay to count towards that minimum number, the old final rule, the incentive pay had to be paid at least quarterly. Now it's simply an annual amount. That's a two-edged sword, because if you are not certain what that person's annual amount is going to be until the end of the year, then that it can be tricky as far as whether you have properly classified them or not. But also, this new proposed final rule does not have the automatic increases that we saw before. If you remember, there was this really bizarre sort of an equation that the Department of Labor came up with, that in essence every 3 years the midpoint was going to go up because the midpoint was being used as the average for the last time, and so it was an automatic increase every 3 years. That is not the case now. Every 4 years it will be reviewed by the Department of Labor Wage and Hour. Regardless of what finally comes out, there are no proposed changes at this point, either to the duties test or the salaried basis. So what to do? Nothing different than what you do normally, other than if you do have folks that you are classifying as exempt that are close to that $639, I think it's $639, number that's there now, don't change anything yet, but simply be aware that you may have to make that determination. Look at if you do have a large group, you may want to look at some different compensation plans, decide on that now. Look at your wage and hour policy. This is always a good time to do that. Make sure that the classifications are correct for the duties test as well, and get ready to communicate the changes when they need to be made. And if you do have to move employees from exempt to non-exempt, be sure that you train them on timekeeping, because folks that have been in a salary basis and have not been keeping time oftentimes don't know how to keep time. And so I know that sounds very simplistic, but be sure that you're ready to train both the employees and their managers on how to do that. All right. Before, I know we're moving a lot faster because of the time. Anything on what we've talked about so far? Wages, harassment, handbook policies, anything that y'all have run into? If anything comes up on the WebEx, our very capable staff back there will read it back to us and let us know. But okay, no questions. We're going to move on then. These are some things across the states. I'm going to just move through these very quickly, just so that you'll be aware of issues that other states are dealing with. If you see your state lit up on one of these, know that it's there. I am fairly hopeful that marijuana in the workplace is not a huge issue for us, but I'm also not naive enough to think that it is not an issue at all for us. And there are some states where medical marijuana, certainly, but also marijuana recreationally. Understand, or at least try to remember, that it is still illegal under federal law. The federal law has not changed. Federal agencies have backed off on enforcement of the law. We can take a different time to talk about what happens to a country when they selectively decide to enforce laws that have been passed, but that's not the issue for the day. The issue for the day is it's still illegal under federal law, and if you are in a state like Tennessee that still does expect federal law to be applied, then regardless of what's going on in New York, California, Colorado, or what have you, it is still illegal in Tennessee. You see some states that have general medical marijuana laws, all the ones with light blue. So it is a very rapidly expanding trend. Those that have general or that have recreational marijuana laws, you see, are not as many, but you see those lit up in green. There are getting away from medical marijuana. Mentioned earlier, one of the major concerns of GCs in this last year's Littler survey is paid sick leave. And how do we deal with paid sick leave on a state-by-state basis? because, again, federal law is not changing in that aspect, so a lot of states are implementing paid sick leave overlays. Again, Tennessee does not have that at this point, but you see the list of states that either have that or are considering it, and again, that is something that is becoming widely popular, and you will also see as an election year begins to crop up on us, it is also something that oftentimes is a political tool as well, and so you will probably see that becoming more and more prevalent. Jurisdictions that have mandatory paid sick leave, again, too small for all the little dots, diamonds, and blue things, but you can see that there are a number of states that are dealing with it in different ways. Be aware of that. Some other trends in states. Some states are now requiring mandatory sexual harassment training. California has probably leading the way in that, but you can also see some of the more of the New England states, and certainly New York, another one of the prevalent ones, and the district as well. Sexual harassment laws that prohibit arbitration agreements that mandate sexual harassment laws. You see, again, some of the same states that have the mandatory harassment training prohibit that as well. We talked a little bit about the Tennessee nondisclosure provisions. You can see that as well. States that do not allow nondisclosure provisions. Do bear in mind, if you are in a position of settling a sex harassment claim, even under federal law now, employers cannot deduct that as an expense. So that is a change in federal law. It's been in play for about a year now. Some employers don't realize that, but if you settle a sexual harassment claim, you cannot deduct that as a business expense under federal law. You see these are states that require written policies. These are states that require specific written policies. I would dare say that there's not any employer in any state that does not have some written policy that prohibits sexual harassment. But these are states that have very specific content-related statutes and ordinances, so be aware of those as well. And then the ban the box is simply the question of, have you ever been convicted? Have you ever been arrested? That type of yes or no, ban the box. And you see that is spreading as well. And again, I point back up to New York City. I have dealt with a number of New York City audits of employers that had no idea that the City of New York had any jurisdiction over them at all. If you have employees who are in the city, or if you have employees that are in the state, a little bit different. The city ordinance is a little bit of an overlay on the state law, but New York City and New York State are very zealously enforcing these laws, including audits where they will ask the employer for their compliance documentation. Doesn't necessarily have to come from a complaint, much like a compliance audit would be done by Department of Labor. So be very aware of that if you're in one of these states that has a ban the box law. States that are now also prohibiting salary history questions. The notion being that if I have been subject to discrimination on the basis of whatever protected category, typically it's gender, then asking me what my salary history was is simply going to perpetuate that discrimination. Whether you agree with that or not, that's the theory behind it, and several states have started banning asking for salary history, and then wage transparency laws, which are employers' obligations to publicize information, whether that is with respect to other employees in the same group, other employees with the same job duties, or even the wages of upper-level management. New York has extended its pay equity law even beyond gender. Most pay equity laws right now are sort of a play off of the Equal Pay Act, which is male-female. New York has taken that a step further. Now, again, they've taken it a step further with their equal pay, bearing in mind that Title VII already prohibits discrimination in terms and conditions of employment, which would include compensation. So this is not as if there is no federal protection already, but New York has taken this to the state level as well, and they've extended it to all protected groups, not just groups of the opposite sex. I worked really hard on this, so I thought I would go ahead and bring this one back. No, that is not me facing the other way. But one of the things that interests me now, I find curious, is I think legislatures spend more time coming up with the acronym for the law than really coming up with the law itself. So this is the Crown Act, okay? The Creating a Respectful and Open Workplace for Natural Hair Act. It really doesn't protect bald guys like me, but I couldn't go past the bald guy picture because I don't get to put that up very often. Okay, but this is State of California. It adds hairstyles to the list of or hairstyles that are closely associated with race to the list of protected racial characteristics under California state law. Before we start California jokes and things like that, it is not simply California, but I thought I would throw in one joke because growing trend was just too easy to let go. Okay, in any case, it is not simply California. Again, some of the similar states that are more aggressively expanding protections to employees you see are in this list as well. There is a similar ordinance in the city of New York. State of New York is awaiting, not sure that he has signed it yet, but when we put this together, we were still waiting Governor Cuomo's signature on that. New Jersey has a similar ban that is also pending. And the EEOC, again, what we're seeing is state laws that are to some extent sort of fleshing out some of the positions the EEOC has taken already. And so the EEOC has also taken the position that, quote, texture or hair texture can be a protected trait. Now, I will tell you that courts are somewhat less enamored with the EEOC's position on that, and so you see a lot of splits on that, and typically you're going to see more of a factual basis than simply hair texture. But enough of the California Crown Act, although kudos to them in coming up with a name that actually makes a word. All right, very quickly we're going to move through EEOC data. How many of y'all are responsible for filling out the your EEOC ones and Component 2 data? Seeing no hands on the WebEx and no hands here, I'm going to move through this really quickly. Component 2 data is simply Box 1 W-2 wage information that goes into your EEO1s. If you do not have 100 employees, you don't even have to file Component 2 data. If you have more than 100 employees, you do. We're going to move through this really quickly because I don't think a lot of folks, certainly not the ones here, but I will tell you there is a deadline if you do have that obligation. It's September 30th. The portal is now open, much to some of us skeptics' surprise. They were able to get it up and get it running, and as far as I know, it is generally working. I would suggest not waiting until September 30th if you or folks that work for you are going to upload the information. A couple of points that are of interest. First of all, Component 2 data is being gathered for your 2017 and 2018 EEO1s. Not just this year, but 2007, well, now it's 19, so 2 years prior, not just the last year. Also, you do not have to provide the Component 2 information using the same date snapshot as you did for your EEO1 Component 1 information, race, gender, and ethnicity. Reporting is by establishment. All of this is information that you need for the Component 2 response. You don't fill all of that in, but it is W-2 Box 1 information. The challenge for most employers is that this information is not easily accessible in one place. You're going to have to be able to figure out how to coordinate your HRIS system, your payroll system, possibly other information. Who is hours worked and what are hours worked? Typically, well, under EEOC guidance, that is the same definition as the FLSA. If you are not tracking hours worked accurately for the FLSA, there's going to be problems with Component 2 as well. How to file, we'll move on through that one. Who will see this information? And this is important for you if you have 100 employees. It is not just EEOC. This data will be shared with other government agencies. This data, in some respects, will be available with FOIA requests, which could mean that any outside or third party with an interest may be asking for that information. And again, the information is going to be available as well by subpoena for folks that are in litigation. So that's item 2, and I think I've got us back close enough. Anything on that before we get into the Tennessee Healthy Workplace Act? I know this is the yes, ma'am. Yes. Yes, let me repeat the question because it was a good question. Does the paid sick leave law include PTO banks? That is, to some extent, it's dependent upon which state's law we're talking about. Most states will allow for the use of PTO, but I cannot say that unequivocally. Let me give you an example, and this is not a state law, but this is actually federal regulation that applies to government contractors, which you are not, but government contractors have had a paid leave law for some period of time, and in that circumstance, PTO is permissible to be used as part of that paid leave. So it doesn't require that you have PTO, because the paid leave laws typically sort of they sort of follow what would be the eligibility for family medical leave. Again, I'm being very general, and so I'm not saying that that applies to all of the states that have that. But it sort of follows that. PTO, of course, can be used excuse me, can be used for a lot of reasons other than FMLA qualifying events. And so if that's the case, then all PTO may not count automatically towards that. So it may work. More likely, what most employers have done, if their current PTO policy is not in compliance with a new state policy, they've rewritten their PTO policy to make it compliant, because it is administratively very difficult to have a paid leave law bank and a PTO bank, because some of it does overlap, others doesn't. So what you're seeing is employers are going back and rewriting those policies to make sure they comply. Anything else on that? Okay. See, Healthy Workplace Act. This is Tennessee specific, granted, but there are other states that have similar laws as well, and that is really the anti-bullying type of laws that we're seeing coming into place. The Tennessee Healthy Workplace Act is not new. 2014 was when it was originally enacted. At that point in time, it applied only to governmental entities, public employers. This last year, Senate Bill 815 made a very minor change. The only change that it made was the definition of employer includes private employment. And so by making that very small adjustment to the definition, it has expanded the Healthy Workplace Act now to employers under the state of, in the state of Tennessee with 8 or more employees. Some things to be very aware of, because when this first came out, most likely those of you, particularly those of you that are in Tennessee, were probably inundated with emails from mostly law firms saying, you've got to have a policy. Let us write this policy for you. This is a cataclysmic change in the law. You got to have one, and you got to have one right now. As you look at the law, there are some questions that you need to think through, and think through fairly slowly before you jump into doing this. No one's going to stand up and say, I'm in favor of bullying. No one's going to say, I don't want to have a policy that prohibits bullying. But you need to be careful how you approach this. First of all, the Tennessee law does not create a cause of action for bullying. It does not create any new cause of action at all. The Act does not require the employer to have any policy whatsoever. Tennessee employer can simply say, that's interesting, that's nice, we have the policies that we need, we don't believe our policies need to change, we're going to go on about our business. That is perfectly acceptable under the amendment, if you're a private employer, to the Tennessee Healthy Workplace Act. What it does do is encourages the extension of these policies by granting an immunity to employers for claims, common law claims, of intentional infliction or negligent infliction of emotional anguish or emotional distress. One of the things to think about as employers is, how often do you even see those types of claims? Sometimes you see those as sort of tag-along claims, state claims that are supplemented to a federal case. It provides no immunity whatsoever to any federal claim for retaliation, for harassment, for discrimination. It provides no immunity to any claim under the Tennessee Human Rights Act. So the immunity that is there, if in those limited circumstances that there may be a claim for intentional or negligent infliction of emotional distress, then it might be of value. But if you want to take advantage of the immunity, your policy has to do two things. First of all, it has to recognize what is an abusive workplace and state how the employer is going to respond to it. And then it also has to require or prevent retaliation against employees that report that conduct. Abusive conduct under the statute is defined as what you see up here. Any act or omission that a reasonable person would find abusive based on the severity, nature, and frequency of the conduct. And then there are some examples that are provided: derogatory remarks or epithets, threatening, intimidating, or humiliating conduct, or behavior that undermines an employee's performance or work. Now, as you start to go through that, what are some things that you start to see? You see anything that starts to look familiar? I would dare say that it probably looks somewhat familiar to your current harassment, retaliation, discrimination policy. It's not identical, but it has a lot of the same characteristics, a lot of the same provisions as your sex harassment policy. Your current sex harassment policy most likely will not be sufficient to comply with the Tennessee Healthy Workplace Act if it is the one that's been around for a couple of years. That's not to say that there's anything deficient with your harassment policy as it now stands. If you want to look at a policy for some reference, back when this was just a state employer statute, the Tennessee Advisory Commission on Intergovernmental Relations, not an agency that you would normally know of or work with, came up with a proposal. It's actually a 23-page mind-numbing document. It is thoughtful. I will say this. It is a very thoughtful document. Some of the difficulty in implementation is that it looks at the issue of bullying in the workplace somewhat in isolation. It does not look at the issue of bullying in the workplace in conjunction with sex harassment, race harassment, age harassment, harassment on any protected category, and how employers are addressing that at this point. It does recognize that employers are prohibited from doing those, but it is very much focused only on bullying in the workplace without really touching on any of those. Now, the policy itself is not 23 pages long. That's the entire document. That includes the thought process, the explanation, and again, I think it is helpful to see the purpose behind it. It does have a policy. You can see the complaint policy, what the policy contains. Again, much of what you see are characteristics of your current harassment policy, defining the conduct that constitutes abusive behavior. Here's where it becomes difficult. Let me ask, first of all, have any of y'all implemented a policy that prohibits abusive conduct with the intent of complying with the Tennessee Healthy Workplace Act? Okay, yeah. I will say if it covers most of it, it doesn't cover all of it, then it still would not be compliant. And because you're absolutely right, most of your sex harassment or hostile environment policies cover most of that. I would dare say that it probably does not contain the appropriate definition of it probably specifically prohibits harassment on the basis of, and then we go through a whole list of those, and then generally because of the Farragher Supreme Court cases from a few years back, you'll have a separate paragraph that says sex harassment is one form of harassment, and then it goes through all of the different examples of sex harassment, and then it goes back to talk about how you would address it, respond to it, investigate it, and the like. So what you see is almost a parallel policy, and that's what employers are going to have to come to grips with and decide what you want to do as far as do you implement the policy or not. I'm not here today to tell you yes or no, but do you implement the policy? The question is, do you keep a separate policy that runs parallel to your sex harassment policy? I would suggest that that's probably not going to be the most efficient. I would suggest that it's going to be confusing to your employees, and certainly have you complained of harassment? Well, I complained of abusive behavior. Well, that's not our harassment policy. That's our abusive behavior policy. You're headed down the wrong tracks. And so you have to be careful that you don't create two policies that run parallel but don't affect the same outcome. Do you want to just lump them all together, throw into your harassment policy, and it also includes abusive conduct, blah, blah, blah? That can be equally difficult because you're really expanding the definitions of what might otherwise be the more traditional sex harassment, age harassment, religious harassment, whatever, race harassment policy that you have. So something to think about as the employer is, do we want to develop this policy or not? You really need to look at how close are we, what do we think the risks are of us being hit with a negligent or intentional infliction of emotional anguish, distress. Do we want to stay with the policy as we are? If you decide you want to go with a policy that includes the abusive workplace policy, then the TACIR's policy is a good place to start with policy language, but don't simply adopt that as is, or you will inadvertently have two different policies that run parallel courses. I always appreciate your time. This is always fun. I enjoy it. I hope you found some value out of this. We'll make sure that everybody gets this as a PDF. Otherwise, thank you all very much, and y'all have a very blessed rest of the day and week.